afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm delighted to welcome you to our virtual platform for today's joint program with the Historical Society for the District of Columbia, its circuit, and the Supreme Court Historical Society, celebrating the life and career of Judge William B. Bryant, Sr. in honor of Juneteenth. William B. Bryant served on the United States District Court for the District of Columbia beginning in 1965 when he was appointed by President Lyndon B. Johnson, and was on the court until his death in 2005. He was Chief Judge from 1977 to 1981. Prior to being appointed to the federal bench, Judge Bryant was a prominent criminal lawyer at the law firm of Houston, Bryant, and Gardner in Washington, D.C. While in private practice, Judge Bryant litigated several high-profile criminal cases, including the landmark case of Mallory versus United States. He's the subject of a great new biography by Tanya Boland, Soul of the Court: The Trailblazing Life of Judge William B. Bryant, Sr. Our panel today features Michelle Coles, William Schultz, and is moderated by Dean Roger Fairfax. I'm going to give a short summary to their many accomplishments so we can leave as much time as possible for their conversation. Michelle Coles is the author of Black Was the Ink, an award-winning historical fiction novel about the Reconstruction era. She currently serves as a commissioner on the Maryland Lynching Truth and Reconciliation Commission. She's a proud alumna of Howard University Law School, and she graduated as valedictorian in her class at Howard. She also is a graduate of the University of Virginia. She clerked in the Bryant Annex to the U.S. Courthouse for the District of Columbia for the Honorable Emmett Sullivan, a dear friend of mine. William B. Schultz is a partner at Zuckerman Spader in Washington. He served as a law clerk to Judge Bryant in the 1970s and took his oral history in 1994-1995. Bill has argued numerous cases in the federal, trial, and appellate courts, including 3 in the United States Supreme Court. Roger Fairfax is the Dean and Professor of Law at Howard University's School of Law. Dean Fairfax previously served as the 19th Dean of American University, Washington College of Law, the first Black man to lead that law school. He previously served as Senior Associate Dean for Academic Affairs and Patricia Roberts Harris Research Professor of Law at George Washington University Law School, where he founded and directed the Criminal Law and Policy Initiative. He clerked for federal judges in the United States District Court for the District of Massachusetts and the U.S. Court of Appeals for the D.C. Circuit. He is a member of the American Law Institute and the Judicial Conference of the United States Advisory Committee, responsible for drafting and revising the federal rules of criminal procedure. We'll take questions at the end of their discussion today, so please share your questions in the Q&A box at the bottom of your Zoom screen. And with that, Dean Fairfax, we welcome you, and the floor is yours, and we're anticipating a great conversation with all of you today. Thank you.
Great. Well, thank you, Jim, for those introductions and that warm welcome. Good afternoon. As was mentioned, my name is Roger Fairfax, and I'm honored to serve as Dean of the Howard University School of Law. And I join you all from my office here at Howard Law, and our storied institution has a proud history and one that is in many ways bound up with that of the Supreme Court, from landmark Supreme Court cases like Brown v. Board and Hurd v. Hodge and Bowling v. Sharp, which were litigated by the likes of Howard Law alums Oliver Hill and Judge Robert Carter and former Howard Law deans Charles Hamilton Houston, Jim Nabrett, and Spotswood Robinson, who's also a Howard Law alum. And there are many others, such as W. Johnson Roundtree, who argued high-profile cases before the court, Pauli Murray, who was a mentor of Justice Ruth Bader Ginsburg and was a co-founder of the National Organization for Women, and of course, the valedictorian of the Howard Law Class of 1933, Justice Thurgood Marshall. And they all share a legacy with the giant whose life we celebrate and amplify here today, Judge William Bryant of the U.S. District Court for the District of Columbia and Howard Law Class of 1936. And I'm thrilled that we have Michelle Coles and Bill Schultz here with us in conversation to discuss the remarkable life and career of Judge Bryant. Given that they've already been introduced, we'll jump right in, and I will start with Bill. So, Bill, in addition to graduating from Howard, Judge Bryant was a graduate of another prestigious academic institution, his high school, the segregated M Street School, now known as Dunbar High School, DC Public School, which educated many luminaries, including the likes of Charles Hamilton Houston and William Henry Hastie and Sadie Alexander, all of whom were children of relatively well-off African-American families of the time. However, Judge Bryant's upbringing in D.C. presented him with great adversity and challenge. And I'd love for you to tell us a little bit about Judge Bryant's childhood and early education.
Happy to, Roger, and happy to be part of this. This is great that the Historical Society is sponsoring this forum. Judge Bryant was born in 1911 in Wetumpka, Alabama, on what he described as a wide spot in the road. His mother was one of 5 daughters of a very proud father who owned a store. And one afternoon, he shooed out of the store some white boys who were kind of harassing one of his daughters, only to find a lynch mob forming outside. So he dressed up as a woman, escaped through the lynch mob, and took a train to Washington, D.C., after which he got all his daughters to come up, including Judge Bryant's mother and young Bill Bryant, who was 11 months old. Bill Bryant went to, as you said, D.C. public schools, including Dunbar High School, and he talked about how outstanding the teachers were, which he explained by segregation. There were very limited opportunities for educated Black men and women. And so he benefited from that in terms of his education. As you might guess, DC was completely segregated. He once told me that the first time he ever saw a white person, other than the local grocer who was Jewish, but other than that grocer, the first white person he ever saw was when he was 12 years old. He graduated from Howard College, and he knew he wanted to go to law school, but his family was against it. His grandfather told him, "You're crazy." And the reason was it just was not a lucrative profession. It wasn't a profession where a Black man could make a living. And in those days, the best job he could hope for, really, in his elders' eyes, was a job in the post office. But as he always did, he followed his own instincts. Judge Bryant was a quiet, modest, understated man, but he was very stubborn. And that stubbornness showed up here. And so, in fact, he did go to law school. The one outlet he had that I'll mention is he was a terrific pool player. He never drank alcohol. He used to say that he killed many plants when he was at parties and offered an alcoholic drink, and he would discreetly pour it in a plant. But he never drank alcohol, but he would go to the pool halls on 14th Street, and his work day would be, he would go to work, he would come home, have dinner with his family, put his kids to bed, go back to work downtown, because it was pretty hard to work at home in those days. All the books were down, in your office. And then when he was done late at night, he would stop by one of the pool halls on 14th Street to relax, a habit that he gave up when he was appointed to be a United States District Judge.
Wonderful, wonderful. And Michelle, as Bill, mentioned during Judge Bryant's formative years, he had to navigate fulfilling his lofty aspirations in that racially discriminatory Jim Crow environment. Did you have any other insight you wanted to add to that?
Yes, I think one of the fascinating things about Judge Bryant's life is with him being born in 1911 and with him passing in the early 2000s and 2005, he really got to experience and see almost the entirety of 20th century America and experience everything that the nation went through in that roughly 100-year period, that everything that was happening in Washington, D.C. And, from the time of his birth in 1911, he was, roughly 50 years after the Civil War and roughly 40 years after the end of the Reconstruction era. And so with this panel discussion taking place around the Juneteenth holiday, I think that's a really important frame to consider his life and his experiences, because as everyone knows, Juneteenth is considered when the last enslaved person of African descent gained their freedom in the United States. But the question that I think really follows is, what did that freedom look like? And the challenges that he experienced, everything from, his grandfather narrowly escaping a lynching that was about to take place right after he was born, to being in D.C. after his family moved to D.C. and being here as a young child during Red Summer of 1919, which was during World War I, when there was a huge backlash to African American communities, and when soldiers were returning from war and were exhibiting more pride, and there were all of these violent clashes with mob violence that was taking place around the country. And one of the places that occurred was in Washington, D.C., to, not long after that, still being a young person and learning about the Scottsboro trials, where a group of 9 young Black boys were falsely accused of raping 2 white women on a train and railroaded through the justice system, where in the initial trial, they almost all received death sentences, and it had to be appealed over and over again, all the way up to the Supreme Court before there was a measure of justice that those young Black boys received. And then again, through various lynchings that took place with Emmett Till, leading up to the civil rights movement, which culminated in Lyndon Baines Johnson signing the various pieces of civil rights legislation in the 1960s. And he became a federal judge shortly after the Civil Rights Acts were signed. And so I think it's just really interesting to look at his life from that perspective and think about what he experienced as the nation evolved and progressed over the course of the near century that he lived.
Well, no, thank you for that. And, we made reference earlier to his legal education, and Michelle, Judge Bryant studied under and with several Howard Law luminaries such as George E.C. Hayes and others. And Bryant both admired and clashed with his dean during his time, Charles Hamilton Houston, who's actually depicted here over my left shoulder in this portrait. And Dean Houston was a pretty serious figure. I think his motto was "No tea for the feeble, no crepe for the dead," and he was again a very sort of difficult personality from the student's perspective. And they did clash. And how do you think that experience impacted Judge Bryant and inspired him?
I think from my reading of the book and the interviews that people had with him, you can tell that he had a great deal of admiration for Charles Hamilton Houston. And I think that he wanted his respect. And just going to the source of the conflict. So Judge Bryant did not come from great financial means, and his family, his grandfather, as Bill said, was not that supportive of him becoming a lawyer because it was not seen as a viable career for a Black lawyer. And the reason being is that there were so few clients that had the means to pay in the Black community. And so if you were a Black lawyer, you were often taking cases in exchange for goods. Maybe you'd get some vegetables one week, or maybe you'd get a few quarters another week, but it wasn't a way it wasn't seen as a way to make a good living. And because Judge Bryant didn't come from a family with a lot of means, he had always been a working person and a laborer and had always worked hard. And that was no exception when he came to law school. He maintained a job. That clashed with Charles Hamilton Houston's vision of what a law student should be, because he said the law is a jealous lover, I believe is a quote from Charles Hamilton Houston. And so he forbade any of the Howard law students from working. Studying the law was supposed to be their one and only vocation. And as Bill stated, Judge Bryant was a stubborn person and had a mind of his own, and he wasn't gonna quit his job. He had a good, stable job working as an elevator man in a building that just gave him the freedom to study, because it wasn't a very intense job. So he could work the night shift and study all night long and still have a little money in his pocket. And so Charles Hamilton Houston and Judge Bryant clashed, and Howard at the time did not provide any financial aid based on need. It only provided financial aid based on merit. And so Howard Law would provide a scholarship to whatever student finished first, definitely first in their first year class, and possibly also second as well. So the top students in their first year class. And Judge Bryant qualified because he finished first in his first year class, and Charles Hamilton Houston would not give him the scholarship. And he said to him that because he had a job, he had no need. And Judge Bryant was very infuriated by that position, and I think he had a little grudge about it.
Well, and you I think raised a theme that, Bill, I'd love you to pick up on, and that is that Judge Bryant believed he was different in many ways from many of his peers, although, most of them were African American. But he felt like he was different because he did not come from the same middle or upper middle class backgrounds of many of his classmates and faculty members there. Tell us a little bit more about that, Bill.
Yeah, and let me I just add one little detail on Charles Hamilton Houston, who, by the way, I think everybody probably knows, but he was really a giant. He was really the theorist behind the civil rights cases in the Supreme Courts in the 40s and leading up to Brown, and really kind of managed them all. And Judge Bryant completely recognized that and completely admired him. But based on his performance in this deal that if you were first in your class, you got a scholarship, he got married the summer after his first year of law school, counting on that scholarship. So he did talk about this a lot. After he graduated from law school, as his grandfather predicted, there were no jobs. I mean, he needed a job to bring in money. Now he was married as well, and so he took various odd jobs. But then he got a job with Ralph Bunche, who was a political science professor of his in college and was a mentor of his. Ralph Bunche had a PhD in political science from Harvard. He was the first African American to get a doctorate in political science. He spent 20 years teaching at Howard, and then the rest of his career at the United Nations. In 1950, he was given the Nobel Peace Prize for the work he did in resolving the Arab-Israeli conflict in Palestine, something that's on our mind today as we talk. But in 1939, Bunche was the chief researcher for Gunter Myrdal's famous study, An American Dilemma, the Negro Problem and Modern Democracy. And he hired his star student, Judge Bryant, who then was able to have, a somewhat academic job, a research job on this project. Interestingly, a lot of this research was in the South, but it was all over the country. But Bill Bryant never traveled to the South. He avoided that because of the memories he had of the experience his grandfather had in the South. In 1943, he then went into the Army, where he worked on Black recruitment and Black morale in a study called Why We Fight. But the idea was to explain, particularly to the Black soldiers, why they were there and what their charge was. He was discharged as a lieutenant colonel, pretty high rank. And he then came back to D.C. He worked on a study called Segregation in the Nation's Capital. And then in 1948, 12 years after graduating from law school, he went out on his own as a solo practitioner, hung out his shingle, and started the business of practicing law.
But circling back to Charles Hamilton Houston, before he put out his shingle, I think he tried to gain employment at Houston's law firm and was disappointed that opportunity was not available to him, and then subsequently hung out his shingle.
Right, that's true.
And so, as was mentioned, Judge Bryant took what we certainly might think of today as an unconventional path after law school. And Michelle, you added that he did seek more traditional employment, but as Bill pointed out, there weren't opportunities available to him. But then he began to break barriers elsewhere. And eventually found employment in perhaps an unlikely place, particularly for an African-American lawyer of the time. And that is the U.S. Attorney's Office in the District of Columbia. Tell us a little bit about that.
Who's that for?
Michelle. Yeah.
Okay. So, so he was hired at the U.S. Attorney's Office in D.C., and there had previously been another African-American attorney that worked there, or previous other African-American attorneys, but they never had the opportunity to work in what was called the big court, meaning the federal court. The African-American attorneys, if they got to go to court at all, were kept in the D.C. Superior Court, trying cases that were considered to not have the same level of importance or difficulty. And when Judge Bryant was interviewing for the assistant U.S. attorney position, he asked the person who was interviewing him, if I cut the mustard, can I go to federal court? And that U.S. attorney said they would give him the chance if he was able to cut the mustard. And so, he worked hard and pushed himself and, took all of these cases and got victories, and was the first African-American at the U.S. Attorney's Office in D.C. that was able to try cases in federal court as a result.
Wonderful.
Bill,
okay, I'm sorry. Bill, any color you'd like to add to that amazing story Michelle just told? I know you spent a lot of time in chambers with Judge Bryant, and he would recount aspects of his career, and wondered if there were any insights you could share on that.
Well, apparently he was quite good. He was a very kind of understated person, but he was a brilliant cross-examiner and trial lawyer. And I think that showed up pretty quickly. Interestingly, he never used notes, either in cross-examination or a closing argument, or even in an appellate argument. He just had that kind of mind. And I'll tell you, one time he told, but he had a ton of integrity. So when I clerked for him, he was always complaining about if there was a police officer he thought was lying or something, not telling the truth. And he told me that one time he put a police officer on the stand on a criminal case, and the police officer lied because he had interviewed him before, and Judge Bryant, I mean, imagine this. He's the only black U.S. attorney there, probably one of the few black lawyers practicing in the courtroom. And he gets up and he says, Your Honor, the government dismisses the case. And he just ended the case. And of course, the officer was shocked and unhappy with him. But, he just was not going to be part of that. The other thing I would mention is, as you can imagine, there were some very traditional conservative judges in that court. And one of them, whose name we'll talk about later, but his name was Schultz. And he had been a government prosecutor, and he was a fairly famous judge. I think he wrote a book on criminal procedure. But he was very, very, much on the side of the government. But I don't know what his racial views are, but you can imagine in those days. But he had great admiration for Bill Bryant. And, that can only be because of the ability that he showed in court.
So, go, Michelle, yep.
Yeah. And I just want to add, I think one of the things that shines through in this book about Judge Bryant's character is his integrity. And before he was an assistant U.S. attorney, we talked about how he had his own practice, and he was, I forgot the name that they had. Do you remember, Bill, the name they had for the group attorneys that would come into the Superior Court and just be assigned cases by the judge? There was a name for them.
Yeah, I don't remember the name. But...
Okay, all right. There was a group of them, and they would show up in Superior Court, and basically they would take the cases of people who, court-appointed attorneys, essentially, that could not afford to pay. And he always appeared to me to be fighting for the people that couldn't fight for themselves. And so I think that is a through line in his life, from what he was as an attorney in private practice to even when he was an assistant U.S. attorney. His interest was in justice more than it was in winning. And as a judge, the same thing. I think he was looking at it from the perspective of what's just, what's right, has the government met its burden, all of those things, and not just locking people away and making sure that the right, proper procedural steps were being followed so that a just result could ensue.
In private practice, as we'll hear, he represented clients charged with murder and rape and so on. But the one kind of client and gamblers too, but the one client he would not represent, which probably would have been lucrative, is drug dealers. He had such an objection and concern about drugs. He did not represent drug dealers.
So it's interesting. After a few years as an assistant United States attorney, he was finally accepted into the Houston law firm. It was actually after Houston had passed away. And it now is the Houston Bryant and Waddy firm. I think in 1954 he joins. And just 3 years later, he is standing before the Supreme Court. And Bill, in the prologue to the book, the author juxtaposes the early doubts that Judge Bryant had to face from his grandfather with this vignette of Judge Bryant arguing and winning before the Supreme Court in the landmark case of Mallory versus United States, which established the McNabb-Mallory rule, which deals with coercion and unnecessary delay and presentation of a defendant. Tell us a bit more about that case, the buildup, and his experience arguing and winning Mallory.
Sure, happy to. So he left the U.S. Attorney's Office in 1954. That same year, he was asked by Judge Alexander Holsoff, who I just mentioned, to represent Andrew Mallory in connection with a rape that had occurred April 7th. There was no fee possible in this case. Mallory was 19 years old. He was from Greenville, South Carolina. Very limited intelligence and mental capacity. One day later, on April 8th at 2:30, he was arrested and he was held. He was given a lie detector test at 8 p.m. At 9:30 p.m., he signed a confession, and then he was not arraigned until the next morning, which raised one issue in the case, whether this was a violation of Rule 5A of the Federal Rules of Criminal Procedure, which says that defendants must be arraigned without delay. In D.C., in a rape case, in addition to deciding whether the defendant was innocent or guilty, if the defendant was found guilty, the jury was the one that decided whether to impose the death penalty. And so during the jury deliberations, the jury sent a question out to the judge and asked the question, if Mallory was convicted, could he get out of jail, or would he be in jail for life? And Judge Holtzoff answered the question that he could give no assurance. And then the jury went back and they immediately came back with the conviction and the death penalty. So there were sort of two important issues on appeal. One was the delay in the arraignment, and the other was the judge's instruction. Judge Bryant, again, remember, with no fee, took the case to the D.C. Circuit, and he lost 2-1. He then petitioned for certiorari to the Supreme Court, and the petition was granted. Now, he was the unusual lawyer who could be very effective in trial and very effective on appeal. I mean, he argued all his own appeals, and he argued this case in the Supreme Court. It's such a wonderful thing. This argument was in 1957, and I was able to go on the Supreme Court site and get the argument and listen to it. And so I did. And what comes across is a very kind of prepared and confident advocate, even though this was his first time before the Supreme Court. What comes across is a mastery of the facts. He talks about how close the magistrate's office was to the police station where Mallory was being held. He talks about how the delay in arraignment was chosen, which is something that Justice Frankfurter picked up on. And he talked for 9 minutes and 40 seconds before he got a question. So the justices must have thought he was telling them things that were useful. He also, I think, showed his kind of skill and confidence in answering the questions. The issue of the jury's note came up, and he was very firm that this was improper, that what Judge Holtzoff was doing when he told the jury he couldn't give them any assurance that Mallory wouldn't get out of jail. He said he was getting into the jury room. He's now part of the jury room. And when he was asked, well, what should Justice Holtzoff have done? He should have said, I wouldn't answer that question. And then at some point he was asked what I thought was a very hard question. Well, what if in the middle of deliberations, the jury starts talking about this and they come upon the fact that, well, if he doesn't get the death penalty, maybe he'll get out of jail, because Holtzoff had explained that the max he could give was 30 years, but then the parole board, it could be as little as 10 years and so on. And Judge Bryant, he just stood his ground and said, if the jury comes up with it, that's fine, but the judge cannot interfere with this. And then he got what I think was the hardest question of all. Justice Whitaker pointed out, he said, well, you would be in a better position now if when this note came back and Judge Holtzoff said what he's going to do, you had lodged an objection. And I think most lawyers getting that question would have explained, they would have spent a lot of time explaining, oh, they didn't know enough at the time, it didn't really matter. It would have been a totally losing argument. But Bill Bryant simply admitted this mistake and moved on. He didn't lose any time, and it didn't hurt him in the end. At the end of the argument, Chief Justice Warren said, and I'll quote this because I think it's kind of moving. He said that he wanted to note a number of things, and that you carried this case through for an impecunious defendant through the Supreme Court of the United States, and we want to have you know that we consider this a distinct service to the cause of justice, regardless of what outcome of this case might be. And Bill Bryant said, "Thank you, Your Honor. It is my honor." When he got the decision a few months later, it was 9-0 in his favor. The court said that the delay in the arraignment was unlawful, and that meant that the confession could not be used as evidence. Mallory was freed. The case changed the police practices in DC and nationwide, which was, of course, the goal. And it's seen as a predecessor to the famous case of Miranda versus Arizona, where the court held that after an arrest, defendants had to be given a series of statements, including that they have the right to remain silent and have the right to counsel.
Great. Extraordinary story. Michelle, would you like to add something?
Yeah, I just want to add a couple of things. One, I just want to note that 40 years after Judge Bryant appeared before the Supreme Court Historical Society, who we are with today, assembled a committee of legal scholars and Supreme Court practitioners to compile a list of most significant oral arguments to the Supreme Court, that arguments that were heard between 1955 and 1933. And Judge Bryant's oral argument in Mallory was one of 411 oral arguments that was included in that list out of perhaps 4,000 arguments. And so I think that's incredible that the significance of his argument and how well he argued it was noted by the Supreme Court Historical Society. And another thing I just would like to point out is I think that Judge Bryant's life experiences in seeing how easy it is for people who are innocent to be railroaded by a legal system if it doesn't have the proper guardrails in place can occur. And in my reading, it seems like that's why he was such a fierce advocate for defendants' rights, because anyone can be accused of a crime, but under the American, the foundation of the American legal jurisprudence system is it's better for 10 guilty people to go free than an innocent to suffer. And so I think the arguments that he was making that the Supreme Court took up and issued the decision, starting with McNabb and through Mallory and till Miranda, was really about enforcing those rights and the protections for the innocent, so that if you are accused of a crime, you have those opportunities to challenge your accuser and speak with an attorney and all of those things that were not taking place so often before the Supreme Court spelled out the need for those type of Miranda warnings to take place.
Wonderful, wonderful. Well, I'm going to ask one last question, and then I will go to the Q&A chat to pose some questions from the audience. They're beginning to populate there. But I'll stay with you, Michelle, and just wanted to give you the opportunity to share some insights on Judge Bryant's career on the bench, this next phase of that extraordinary career.
Yeah. So, I mean, once again, I think you still see him holding that same high standard of wanting to make sure that the government is meeting their burden and proving their case and ensuring that fairness exists in his courtroom. He would, some of the comments that I saw that I thought were pretty funny from interviews is that, he would try to give people advice when they were practicing before them. Like, are you sure you want to call that witness? Do you think you maybe should stop here? And so that was interesting of how he would try to provide that feedback and help elevate the lawyering that was taking place in his courtroom. But one of the things that I think stood out a lot for me was with the passage of the federal sentencing guidelines and how vehemently he was opposed to them because he thought they took away the independence of the judiciary by imposing, a set of sentences that must be given without having the insight that a judge would have into the particulars of the case and the circumstances and the background and all of the various factors that would go into a sentence that a judge may announce. And so when the federal sentence guidelines were passed and were made mandatory, at that point, he had already taken senior status as a judge, and he made the decision that he wasn't going to hear any more criminal cases because he, going back, I think, to that same stubbornness/integrity, with two sides of the same coin. It seems like if he didn't believe in something, he wasn't going to do it. And so he took himself off the criminal docket. If there was ever a time where he did need to step in and hear a criminal case for another judge, when it came time for sentencing, if the defendant was found guilty, he would hand that case back to the original sentencing judge. And so I think it also shows his prescience that the sentencing guidelines were ultimately made non-binding on judges. And I think that just kind of is proving his instinct correct once again.
Great. Thank you. And Bill, what was it like to clerk for Judge Bryant, and how would you describe his style of jurisprudence?
Oh, there's so much to say. So when I clerked for him, it was the same year as the famous Watergate trials. And as a law clerk, I could get in to see them at any time. And so often I would go and I'd watch the trial before Judge Sirica, and I'd come back, and of course he wanted to know everything about it. And, I'd describe a cross-examination or what was going on, and then he would tell me how he would do it. Or he would do the closing argument for one of the defendants. And it was always better than what I had watched downstairs in Judge Sirica's courtroom. He, a lot of times in a trial, if it wasn't a jury trial, after the lawyers were done with their examination, he would start asking some questions and do a little cross-examination. But you really got a chance of seeing just an extremely skillful lawyer. I mean, one thing I always found interesting, in practicing, he was a criminal lawyer, so he had never done, except a very small amount of civil law. And yet he was able to come into the court where a very big part of the docket is civil cases and be very, very successful. He had one case challenging the conditions of the DC jail that he was very proud that it was the oldest case on the docket. And he had managed to do this case, improve the conditions of the jail, and keep it away from the Court of Appeals through his, by being very careful about his rulings. He was a real believer in the power of lawyers. And there was something else I did, and I copied down a quote that he gave to the press about this. And here's what he said. He was holding up the Constitution. He said, "Without lawyers, this is just a piece of paper. If it weren't for lawyers, I'd still be 3/5 of a man. If it weren't for lawyers, we'd still have signs directing people this way and that based on the color of their skin. If it weren't for lawyers, you wouldn't be able to vote." So he always, it was really kind of a wonderful thing, but he always believed that lawyers, could really make a difference. And maybe that's because he had made such a difference. He had an endless number of sort of sayings. So if I came to visit him, he'd say, "What are you doing down here on Skid Row?" Or he would say, "There's no end to the good a person can do if he's willing not to receive the credit." Or he absolutely avoided press attention. He would not talk to the press, but some judges did. And I remember about one of those judges, he said, If you live by the press, you die by the press. And just to tell you a little story about this, when I was clerking, or it was later, my wife was a reporter at the Washington Post, and she was doing a weather story. And it was about the hottest day of the summer. And she needed to talk to somebody who remembered the next hottest day, which was in the 1930s. So I said, well, call Judge Bryant, talk to him. So she called Judge Bryant, and he completely remembered the day. He gave her great color. It was absolutely terrific. And she said, well, this is all great. Now, can I quote you? And he said, absolutely not. He would not have his name in the paper about a weather story. So he really, he was not out for himself. He was really about doing the best job and justice. He died at 95. He was still trying cases, working a couple weeks before he died. And I think 2 years before he died, he tried more cases than any judge in that court. So that was Judge Bryant.
Yeah. Well, again, amazing stories from you both. And I mentioned I would go to the Q&A from the audience. And one of the questions was directed toward his activity in senior status and whether he continued to try cases. And so you've answered the first question already. Another question from the audience is about his decision to practice law finally in 1948 after engaging in all of the research work that was described earlier. Could either of you share some insight on why he made the decision to move toward the practice of law there in the late 40s?
This is total speculation, because I never really heard him say, but it's always what he planned to do. And I suspect that after being in the Army for 4 years, maybe he had saved enough money that he could kind of take this plunge. And I think it was either going to be then or never. And he did get the GI Bill, gave some subsidies to former soldiers. And so I think he had help there, at least studying for the bar and so on. But I think he had to give it a try.
Yeah. And before he practiced law, he was a researcher again on another study that looked at segregation in the nation's capital. And so he did that again. But I agree. I think the GI Bill and having access to some funds in that way maybe gave him the ability to step his foot into practicing law.
But he never made any money. He got a significant raise when he became a federal judge. He told me that's what gave him enough money to send his kids to college.
Absolutely. Well, another question is asking our panelists to identify what they think is the most significant case over which he presided as a judge. So we talked about Mallory perhaps being the most significant case he litigated, but what would you say in terms of his judicial career?
I'm going to add one. I'm sure Bill can answer this question better than me. But one that stood out for me was one of the abscam cases where a congressman was wrapped up in an abscam where, the FBI were basically set a trap to see, who might be willing to accept a bribe. And Judge Bryant, even though the jury found the person guilty, Judge Bryant was so upset by the circumstances around how this person was essentially entrapped. And he said, you created a crime and you created a criminal, and that's not what the government is supposed to do. That's not the purpose of government, is to create crimes and criminals. And, had the government not do this man might have lived a completely law-abiding life. And the first time that the FBI approached the congressman, he turned them down, and they came came back again. And so he said, that's where you really messed up is, you shouldn't be doing that. But the circuit court ended up overturning him throwing out the jury's verdict and made the conviction stand. But again, I just thought that was another excellent example of his integrity.
Yes, and he didn't. He didn't care if the D.C. Circuit was going to overturn him. He felt so passionately about that. He was just going to do what he thought was the right thing. I think the D.C. jail case was a very important case that I mentioned. He had a case. It was called Dellums versus Powell, and it was during the demonstrations against the Vietnam War. I think it was President Nixon, and they had gone around D.C. and arrested a lot of the demonstrators, including there were 1,000 people demonstrating on the Capitol steps who had been arrested and taken to the D.C. Armory. And the ACLU brought the case. Dellums was a member of Congress. He wasn't arrested, but the claim for him was his audience was taken away, so he deserved damages there. But, that was a trial of 6 weeks or so, and it was a favorable verdict, millions and millions of dollars. It was upheld by the D.C. Circuit, but it really established the First Amendment right to demonstrate. And you couldn't just be arrested because you weren't liked. He had the case, the first case. It was a lawsuit that established the 18-year-old right to vote. I know he was always very proud of that. He had some cases about Indian rights. This is not one of his best cases, but this says something about him. He had one case. It was called Himmelfarb, and it was a state fight between members of a family, and it just tore him apart that this family was really fighting, and they were going to go. And he knew what the trial was going to mean. And so I remember him saying, I'm going to settle this case. And so he called the jury in to put the fear of God into everybody, and then called everybody into the conference room and made them sit down, and he managed to settle it. When he was a lawyer, occasionally had divorce cases, and I was told he always tried to get the couple back together. He didn't really want to represent anybody in divorce.
Well, I have another question, and actually two questions I'll combine. One question, no, it's more of a comment that said the thing that most astonished me about Judge Bryant was his lack of rancor at the discrimination he had overcome. And a second comment or question was about the federal court library excluding Black lawyers during the time in which Judge Bryant practiced law, and a question about how he handled that.
Yeah. So with the library, there were Black employees that worked at this library, and one would give him access late at night, so he would be able to do the research that he needed to do. But yes, the DC bar controlled access to the library, and it was a racially discriminatory, exclusive organization, and only members of the DC bar could practice in that library. And so it definitely, I think, impeded the practice of law for Black attorneys. And in terms of the lack of rancor, it appears to me that he was very forward looking and was focused on the progress that was being made and the future that he was building. But I'll turn to Bill because I didn't know him personally, and so maybe there was more.
I will tell you, on that library, I went down with him, and he introduced me to the librarian, a guy named Mr. Juergens, and then later he told me he's the guy who let me in late at night when the library was closed to study. I can't explain it. He was like Nelson Mandela. Nelson Mandela was like this too. He had no bitterness toward people, and he could. I mean, there were judges on the D.C. Circuit who were very racist. But I remember, but one of them he had known in practice, and he was a good lawyer, and he would talk about how good a lawyer he was. I mean, he did not have bitterness toward people, no matter what their views. On the other hand, he really stood where he stood. I mean, it's not like he wasn't. When the D.C. bar, which excluded him from the library, when they integrated and all his friends joined, he said, I didn't want to join. The Redskins, the football team, were a big deal when I was there, but their, historic owner, George Preston Marshall, they were a totally racist team. And he just had no interest in anything having to do with them, no matter what they were now. So he had these really strong feelings, but yet he never expressed it in interpersonal relations.
Well, we have time for one more question, and that is, what led to the federal court annex being named for Judge Bryant?
I can, Michelle, I mean, I can tell the story.
Yeah.
This is what I was told. So the chief judge was Judge Hogan. And, the annex is for the Court of Appeals and the district court. So, you would think it would probably be named after an appellate judge, but apparently Judge Hogan, he really thought it ought to be Judge Bryant. Judge Bryant had practiced there for 20 years and been a judge there for 40. And he never took vacation. So he had clearly been there more days than anybody else. And Judge Hogan sent a note to all the judges in the circuit and said, unless anybody objects, I'm going to put in for Judge Bryant, be named the William B. Bryant Annex. And there were no objections. But the problem was a bill had to be passed by Congress. And it's the kind of bill that a single senator could block. And so it was blocked for a very long time by a senator who, it was probably because he was African-American, but the excuse was we only name courthouses after people who have died, even though it wasn't really quite true. The Harry Byrd Courthouse in West Virginia had been named way before Harry Byrd died. But eventually, John Warner, who was a senator from Virginia, but who had been a U.S. attorney when Judge Bryant was in private practice and credited Judge Bryant. Judge Bryant apparently would go and have dinner with the U.S. attorneys and teach them the tricks of the trade. And so he's now a senator, and he managed to put on another bill this naming of the courthouse. And that passed, and it was just a few days before he died, but he knew it had actually gone through.
Right.
And speaking of teaching, he also had a long career also teaching at Howard Law as an adjunct as well. And I believe the Inn of the Court was also named after him. And so that teaching and mentoring was
that's a really good thing to remember. He despite the fact that he worked all the time, every Saturday he spent the whole day for 30 years teaching trial practice at Howard Law School.
Yeah. And that's a great segue to my turning it back over to Jim, because one of the final questions in the queue is from an alum of the Howard Law School who expressed surprise that the school and the student body don't celebrate Judge Bryant's legacy more. And I pledge to that alum that has now changed. And Bill and Michelle and I did a program earlier this semester for the students, and you're going to hear a lot more about Judge Bryant coming out of Howard Law in the months and years to come. So thank you for that. And thank you, Jim, for allowing us to have this program.
Thank you, Dean Fairfax, and Michelle and Bill. Thank you so much for participating and joining us today for this fascinating discussion. And I know we could have gone on for another hour. And Bill, I know you're right about Judge Hogan really promoting the name of the courthouse for Judge Bryant. I know that background personally, and he was instrumental in it. We want to thank the Historical Society for the District of Columbia Circuit for co-sponsoring today's event, and for the great work of Jim Rocap and Leith Alvero to making today's presentation possible. Excuse me. The biography, which has been referred to throughout the discussion today, and thank you, Michelle, for holding it up. There it is. It's Tanya Boland's biography of Judge Bryant, Soul of the Court, The Trailblazing Life of Judge William B. Bryant Sr., can be ordered directly from the publisher, and a link has been added to our chat room on this event. We have also ordered it for sale in our gift shop at the Supreme Court. So hopefully you can purchase it there also. His is a story which you've heard today in a recap of an hour, but it's a story that more people should know about. And we encourage you to learn more about his life and contributions. The video of today's conversation and previous virtual programs from the Supreme Court Historical Society can be found on the Society's YouTube page, and a link to that is also in the chat. A survey will go out later this afternoon to everyone who registered in advance. We encourage your feedback in that survey. It helps us make these lectures and conversations more informative and engaging. The Society's next virtual program is on July 14th at noon, and we will pay tribute then to the late Justice David Souter with several of his former clerks. Registration for that event is open on the Society's website at www.supremecourthistory.org. And with that, we are adjourned for today. And Dean Fairfax, thanks so much for moderating and this wonderful discussion. Thank you again, Michelle Coles and Bill Schultz as well.